Okay, and Mike Donovan is here. He just needs to, uh, but I know Mike is here, allowed to talk. He's got his thing off, promote to panelist.
I see his picture.
You can see his picture? Good. Is Mike's picture now?
I don't see, well,
I don't see it yet.
I see his name, but I don't see the
Okay.
actual picture. But he's in.
All right. Okay. Well, anyway, I would like, we're going to need Mike to somehow identify that he's here for the
I'm
meeting.
here. Can you hear me yet?
Yeah.
Hey, okay, here we are.
Okay.
And it is now 7:01. We're almost on time. And welcome everyone to the scheduled meeting of the Board of Appeals. It's being conducted with Zoom, and it is being recorded. I would like I can see from the Zoom list that all board members are present, but we should announce that officially. And, you know, I saw Carol at Planning Board has a great idea. She calls out the members and they just say present, which, okay. So Nadir, Ahmed, are you present?
Present.
Nancy Green,
Present.
Laverne Lovell,
Present.
Mike Donovan,
Present.
and George Schmetto, present. And thank you, Carol Lisbon.
That was very good.
We should do that for the votes too.
Absolutely.
So
Absolutely.
efficient. I loved it.
And Kristen Gagalis, our counsel, is present also. Tonight, as shown in the published agenda, tonight we're going to deliberate on final text of our decision to deny the appeal of Thomas and Christine here from a decision of the building inspector, which was related to a proposed building plans on their property on Dover Assessor's Map 6, Parcel 103, with the address of 15 Park Avenue, Dover, Massachusetts. And for this session, the public, it's open, but this is not going to be a session where anyone speaks except board members and our counsel. We closed the hearing at our May 7th hearing at our May 7th session for purposes of accepting any further information after that. So board, what we've done since that May 7th meeting, I have drafted a decision to follow our votes. I have reviewed that with Kristen and Nina from the law firm that represents the town. Their comments were very helpful, and this draft reflects, I believe, the view of their office, and it was something that we felt was important, that this not just be a decision of us civilians. Kristen, am I representing that fairly?
Yep, I think that's perfect.
Okay, thank you. What I would like to do now is share my screen to show some things. Okay. And okay. And can everyone see my screen at this point?
Yes.
Okay. These are the votes that we took. And you can see we rejected the appeal and voted to have me draft a decision with counsel. And that's been done at this point. And now what I'd like to share with you is the actual draft itself. Okay.
Yep.
And yeah, this is the way it's set up. And you've all seen this. And again,
Yeah, I read it today again.
Oh, good. Thank
Yeah,
you.
so
And
it's fresh.
for procedure, because of open meeting law, yeah, I'd like to be clear, none of us have been commenting back and forth.
Mm-mm.
Although everyone has reviewed this at this point, I hope. We are reserving this session for comments and edits so that the public can see exactly how the board does this. You can see we start out with a recitation of the appeal, word for word from Tom and Christine here. We published a notice of hearing twice, and the text of this notice was actually reviewed with the hearer's attorney before it was sent out, which I think is a good procedure. The proceedings itself, well, we have a complete list of record materials that I've sent separately, and we'll look at that in a minute. But what we did was we had a hearing with 4 public sessions and a site walk. And the decision lists each of those things that happened. And then we had findings, which are basically facts. Properties in R zone, 1 acre R zone. It has a boundary that abuts Oakley Road and also Park Avenue. That the lot is shown on a subdivision plan that was recorded in land court in 1926. And our setback requirements for lots that abut 2 streets. If it's a corner lot, we know the setback is 20 feet from each street or 7.5 feet in cases where the abutter is not a road, but say a neighbor's lot. And the building inspector himself in 2002 had approved, and we find this, and this is part of the record, had approved Tom and Christine putting an accessory building on their lot within 10 feet rather than 20 feet of Oakley Road. And there were no, yes, Laverne.
Was that the same building inspector or was that the one before this gentleman?
It was a different inspector.
Different one. Okay. So
Yes.
this is, yep. Okay. Thank you.
Yes. And it looks as if none of us were there, but it's basically they were just approved plans, not a detailed written finding or any evaluation we can tell of what the setback requirements would be for a corner lot.
Mm-hmm.
And again, one of the things we've determined with council is that we are not bound because of one building inspector's decision long ago. We are looking at this with fresh eyes, and we're looking at this really with the view of the building inspector today. Now, after that 2002 decision, Tom and Christine here correctly followed our rules that once you have a lot with accessory buildings, you need to go to the planning board first for a site review process. And I think the point of that procedure is to determine if the use of the property has changed. And the planning board went through this and they decided that the proposal would be fine. However, they did not decide on the applicability of the corner lot requirement. And they correctly decided that any variance for setback would be done through the building inspector department or the ZBA. So they left that up to the building inspector to determine if the setbacks were proper. And after receiving their plans shortly after the hearers had, and the hearers acted in very good faith on this. I want to be very clear about that. They followed the procedure. And the building inspector, though, looked at this, and as he was asked to do, he looked at it for setback purposes, and he determined that their plan, the proposed plan, which again would show 10-foot setbacks, that it didn't show 20-foot setbacks. He determined this was a corner lot, that it was abutting two streets, Park Avenue and Oakley. And therefore, he rejected the building plan. He said, you've got to be 20 feet away from Oakley Road. The Heaters then filed a timely appeal. And through their attorney, we, looking at this and the need for a number of sessions, the Heaters, through their attorney, extended our time for a final decision to May 23rd, this Friday at 5 p.m. We know the applicants, the Heaters, we and their counsel feel strongly that Oakley Road is not a street. And so we understand that position. They feel the setback requirement should be only 7.5 feet from Oakley, that their proposal of 10 feet is more than adequate. They simply do not feel 20 feet is fair or required legally. Now, another thing we found, and anyone who went to town meeting in 1998 would know, town meeting actually accepted Oakley Road as a street and it as a public way, and it voted to that the selectmen could acquire Oakley Road by purchase or otherwise, as may be necessary to accomplish the purpose of making it a public way. There was no action taken by the selectmen to acquire this. In fact, and there is a difference of opinion between the applicants and neighbors who've also represented by council as to whether it was even necessary for the town to acquire ownership. There seems to, but the title itself, if you went to the land records, it is not owned by the town, not at this present time. There was actually a feeling, I guess, in town that the vote itself was sufficient. But that's open at this point. We do know our council and her office are examining this with the selectmen for a number of other roads in town, which have been accepted at town meeting, but where there has not been a formal transfer of title on the land records. So the other thing they say is that even if it weren't a public road, it can't even be a street. And the basic thought there was that it's mostly unpaved, in fact, and if it's unpaved, their counsel, Vinnie O'Brien, who we all know, who's done an awful lot of work in town, basically they pointed out that if a street, even if it's on a subdivision plan, if it's just a street on paper, it's not a street at all, neither a public way nor a private way. That's what we believe their situation is. Now, we went there, I think we all agreed. You certainly can't drive a car or a fire truck on all of Oakley Road. There is a small portion of, in fact, all of Oakley Road is actually paved to where it runs around and connects with Park. But that stub portion, which is unpaved, the question is that a street of any kind if it's unpaved? We found that going over there, that the stub actually connects to the Church of the Most Precious Blood parking lot, and attached to a submission from John of the Dohertys, who live across the street. There was actually a copy of a 40-foot right-of-way that connects. It runs right from Oakley Road over to Center Street and town land. Not that that's necessarily material for the decision, but it shows that this is not just forever possibly going to be a dead end unpaved stub. So we deliberated at the meeting, and we agreed these are well thought out arguments on both sides, and they were conducted by attorneys who know their stuff, and the entire way in which they presented themselves was extremely well. It was what you would expect in a small town where people like each other. It was not the screaming and shouting that you see on television, and that I'm very, very grateful to all of the attorneys. We're all grateful for that, the way they did that. There were also citizen comments. Citizens raised a number of concerns which dealt with possible use of the property for businesses and other. We don't we are not making a decision on that. Our decision is based strictly on a very, very academic point. Is Oakley Road, including the stub portion, is it a street? And our reasoning is shown as follows, that if it's not a public way, it is still a street under our Dover bylaws. And our bylaws are, go way beyond having to be, you don't need to be owned by the town to be a street. Our bylaws are clear. It can be public or private way, an alley, a lane, a court, or a sidewalk, which is open or dedicated to public use. That's what our bylaw says. And we are referred by our bylaws to the 11th edition of Merriam-Webster. And if we were deciding what's a lane, it can be a narrow way or track, and a track could even be a path made by repeated footfalls. Well, we do know that, and be clear, we're not saying that every path and footpath in Dover is a street. But we did have knowledge after walking this and after hearing from neighbors. They do, and they have for years, walked on that stub portion, both for recreation and then to get on to church. And it's also that walking, you can get to Carroll School by way of that stub. So it's not just a little thing in the woods. Now, I want to be clear, and all of us do, we are not deciding that every trail and footpath in Dover is a street. That is way overboard to think that we are ruling that. We're limiting our decision to this appeal and its special circumstances, all of which lead us to believe this is a street, even if it's not a public way. It's laid out clearly on a subdivision plan that was recorded in the land court. Town meeting did accept it as a public way, and it didn't differentiate the stub from the paved portion. Neighbors have used it for decades for vehicle traffic up to the stub and for foot access on the stub to the church and the neighboring school. Now, the Girdlers who live across Oakley Road, they even use a small portion of the stub as entrance to their driveway. So there's more here than just a meandering path or trail. This is something shown on a recorded plan. And the fact that it is a, quote, paper street on the stub, or at least for most of that, we certainly agree that, except for the small portion the Girdler's driveway uses, that the stub is a paper street. But even paper streets are streets under our bylaws. And this is This comes just from looking at the bylaw itself, and I think using a fairly common sense interpretation. We have a definition of street, which is very, very broad, but we also have in 185-19 a definition of street frontage. Now, what is that? Street frontage, if you go into 185-19, that is, a lot has street frontage when it is on something that is paved and usable by vehicles. And there are a number of clauses in 185-19. But I think the way in fact, I know the way we read this and is that even though the stub may lack street frontage in its present condition, that doesn't prevent it from being a street at the present time. And street frontage is actually irrelevant for this determination of whether 15 Park is a corner lot. Just looking at the plain language of our zoning bylaw, a corner lot is one that is bounded by two streets. It is not a lot that has frontage, street frontage on two streets. It simply is abutting two streets, meaning the broad definition of street. That is simply the way this works. Now, when being a paper street, there are some things that can't be done on a paper street. And the main thing is you can't use it as frontage to build a house. You couldn't go to the planning board and say, hey, I'm carving out a lot on a paper street and I'm going to build a house. They would say, no, 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 you can't do that. You've got a lot. Your lot's on a street, but you do not have a lot with street frontage. And until you have one, you can't build. So that means it's not justification to build a house, but the other requirements for, that refer to a street and for a lot, the setback requirements, everything, they still exist. They still exist. So, we found it just the only sensible way to interpret our bylaws. And we also, in the case of being a public way, we're not ruling that it's not a public way because the selectmen did not acquire it after town meeting. But we are simply finding it's not necessary to be a public way. Being a street is enough. So Oakley Road is a street. That means the Here's property is a corner lot abutting two streets, and the setbacks need to be 20 feet from each street. Okay, before I get on to the actual decision here that is proposed for this, I would like to know, does anyone on the board want to add or correct something here? And then after that, before we get to the proposed decision, I do want to go over the actual documents that are part of the record, and we've got those listed separately. I'll show them after this, but for as far as I've gotten, I apologize for being too wordy. I hope this has been clear. Does anyone want to correct anything so far or add to something? Okay.
Yeah, looks good. Looks good.
Okay, thank you very much.
Looks good.
I think then what I will next look at for us is we have record documents, and we've got I've listed everything that we have gotten. Some of these are actually attachments to the submissions from the attorneys. For example, the building inspector denial, the copy we have of that is actually attached to the the appeal that the hearers filed, because they're required to do that. But I'm going to just take that off right now. But you can see this is really kind of a history of everything. And I've tried to do this by date, listing the memos. And what we've done, thanks to Chris Costello, our assistant town manager, we've been able to list these, maybe word a little differently in times, on the web page that we have for the Board of Appeals on the town website, which I think is a great new way for us in matters that are of significant interest, so that the public can be looking at this and seeing exactly what we see, including the briefs from the attorneys on each side. I think that's helpful. But this would be part of the decision. It would be attached to this. And I think unless someone wants to add something to this, in many ways, I don't know how much of this is actually necessary for our decision, because we're basing it, for the most part, it's just strictly on the way the statutes are written, the way our bylaws are written. What's the definition of street? And does a street without street frontage, does it still qualify as a street? I mean, that is, but it's important that we do list the things that came before us. And then the next thing, okay, this is something I've shared with everyone. Lots of emails coming in. I can tell you honestly, there's nothing I found in any of these emails that was unique or more material than what the lawyers briefed, but this is something we get these, and I share them with the board so that we can see those. I think maybe if we might consider a procedure in the future not to accept emails in matters like this. It can get to be overwhelming, and maybe just have people submit their comments on paper to the town clerk. But we can talk about that later. So anyway, that is okay. Where we are, and now let's get back to the decision itself. So here is our, well, we've already voted this way, but the decision we put on file, and which will be the one that, if the hearers do decide to appeal, will be the one they would be working off of with their attorney. Number one, the board denies the appeal from the January 14th, 2025 decision of the building inspector. And the board votes to confirm that decision of the building inspector. This means new accessory buildings may not be constructed on the hearers lot within 20 feet of Oakley Road, and current structures may not be relocated to within 20 feet of Oakley Road or Park Avenue. And for this purpose, all of Oakley Road, including its undeveloped stub portion, is considered a street within the meaning of the corner lot requirements of 185-23 and the definition of street in bylaw 185-5. This was a unanimous vote with our associate members concurring. And then we have something that our counsel, Christine, has actually helped prepare. It simply says, in terms of appeal, that's according to a specific part of the Massachusetts general laws. That's not something that we change. That is something that is state law. Generally, that means after it is recorded with the town clerk. In most cases, there would then be up to 20 days to appeal by making a court filing. We're not going to get into all of the procedure and all of the things that are involved in interpreting a state statute. We are going to refer people to it, and they and their attorneys can then go to court subject to following that statute. Another thing that's important is that any action that's taken in disregard of this is at risk. A court will order reversal of the actions in whole or in part. Any construction performed may be ordered undone. And most importantly, this does not approve or condone any prior actions, including construction, reconstruction, or moving of any structure without the prior written approval of the building inspector, unless that is exempt under Massachusetts law due to passage of time. So this, and Christine, what this means basically in layman's terms, I believe things that are done that have existed for at least 6 years don't get undone, but other things are subject to, appropriate action. Is that fair to say? Or
Yeah, that's more or less correct. It's a little more nuanced, but that's
yeah,
essentially,
okay. Yeah. So that is basically it. And if the board is comfortable with this, I think I would then like to have a roll call vote, saying say aye or nay if you did not feel it was proper. And then based on that, this decision will be final. Laverne, you are.
I can sign tomorrow or the next. I'm here every day.
Excellent. Oh,
Yeah, I'm
that's
here every day.
okay. Good.
Yeah.
So that would be done. Okay. Well, let's have a vote, please. And
No, George, just one
yes,
quick.
yes, my dear.
I'd emailed you about this. I think you may have mentioned it, but just my last name's misspelled in that portion of the decision. So just
Oh dear, wait a minute. Okay, so that yeah,
it's
I've
an
got
E instead of an A.
MED. Did I say MAD?
Yeah.
Oh goodness. Okay, apologies.
No worries. You had
Let
it
me-
right in all
let me
the other
try.
materials.
I think Ahmed and Chimento had a contest as to whose name's been misspelled. Okay, I'm older, so I would win. All right. Okay, let's have votes, please. Laverne Lovell, how do you vote?
I'm in favor. Aye.
Nadir Ahmed?
Aye.
Nancy, if you were voting here, George Chimento, aye, and Nancy Green, associate member, were you voting? Do you concur?
I do. Aye, in favor.
And Mike Donovan, associate member, were you voting? Would you concur?
Aye.
Thank you. Okay, I would say that that wraps this up at this stage. And I really, again, there are no hard feelings at all. If the hearers decide to appeal, again, everyone is a neighbor there. We're all neighbors. Gosh, it's a small town. And people have every right to appeal and every right to protest. And that shouldn't change, hopefully, the way people go about day to day when you see your neighbor. Okay, that part of it. I think at this stage, the next thing on the agenda is that we review some minutes of our May 7th meeting and then see if anything else is worth discussing administratively. So I will stop sharing screen. Good, okay.
I don't think you need me for this part.
Kristen, yes, you're right. We do have that minute by minute budget with council.
Yeah, that's why I like to hop off. I know you don't need
I
me.
know,
don't
at
wanna
first
be-
we thought you were doing this just for the fun of it.
Well, as much as that is true as well.
Okay,
I'll let you get
well,
nice to see you all.
thank you
Thank
very
you.
much for your help, Kristen.
No problem.
Okay, and actually now I probably should share the screen again just for those minutes, okay? Okay, these were circulated earlier.
Yep, I read it.
Good.
Yeah.
And Nadira, I do have your name, most of it, okay. But yeah, this just followed through on what we did on May 7th. And like all of our meetings, all of our minutes, they get posted on the website as soon as we approve them. We are fully up to date with the obligation to have timely minutes. If there are any edits or suggestions, let's have them. And if not, let's do a roll call vote to approve. Any suggestions or edits?
No,
No
Okay.
suggestions or edits, so I move to adopt the meeting minutes as circulated and as presented.
Thank you, Nadir. A second?
I'll second that.
Thank you. And our roll call vote, Laverne Lovell,
Yes. Aye.
Nadir Ahmed,
Aye.
Nancy Green,
Aye.
Mike Donovan.
Aye.
Good. And Nancy and Mike are concurring as such, and George Chimento, aye. Okay, so that gets this. And now, is there any, yeah,
Got a meeting next week.
yes, that's
Next
right.
week. Yeah.
Yeah, my Betsy says I'm seeing you guys more than hers. But yeah, we do have a big meeting next week, and but I think if there's anything else to discuss, let's do that, and if not, let's vote to adjourn.
I just have one comment.
Yes, Laverne.
You do a fabulous job. I used to do the minutes for like 10 years. I did the minutes, and my minutes would say we had a meeting about the HERS at 15 Park Avenue. It was this much on the minutes, handwritten. That was it. That was a long time ago, but it was like, wow, this is much more
Well done,
detailed.
George. Well done. I know there's a lot of work. Thank
Well,
you.
very
much.
well done.
Geez.
Extremely well done. Thank you.
Well, listen, it is just no, it's I don't want to sound too corny, but you know how well I think of you. And okay, motion to adjourn, please.
So
Second.
moved.
So moved. Second.
Okay, and everyone, let's just shout out your names for old time's sake. Go ahead.
Nancy Green, aye.
Laverne Lovell, aye.
Nadir Ahmed, aye.
Mike Donovan, aye.
And George Chimento. See
we'll
you
get the-
next week.
We'll get the hang of this, George.
Thanks.
Thank you very much.
Thank you.
Uh,
That was great.
Thank you.
Bye.